You are Sint Maarten. You are Sint Maarten.
The URSM, the Unified Resilient Sint Maarten Movement, being a political movement, will be hosting a weekly radio program called UR Sint Maarten every Wednesday from 6 to 7 p.m. on the Radio Mix 94.7 FM. I myself, Dr. Messalina, the political leader of URSM, will be hosting this radio program in which current issues, actualities and general topics will be discussed with the people of Sint Maarten. So join us every Wednesday on Radio Mix 94.7 for our radio show UR Sint Maarten.
You are Sint Maarten. You are Sint Maarten.
Dear people of Sint Maarten, good evening. Welcome to your radio program UR Sint Maarten on the Radio Mix 94.7 FM. I myself, Dr. Messalina, will be your host in this radio program. As you know, I'm the surgeon in Sint Maarten Medical Center, serving the people of Sint Maarten day and night with my profession. And of course, as is known already, I'm the political leader of the URSM, the Unified Resilient Sint Maarten Movement, that will contest the upcoming parliamentary elections for country Sint Maarten. As you know, URSM stands for putting the people and, of course, the country above self, and we believe in educating and informing the people of this country. We from the URSM also strongly believe that there should be a sound balance between economic growth and a welfare in a society. And of course, we from the URSM strongly believe in education as a main pillar to carry a autonomous country like Sint Maarten. That is also the reason that we from the URSM decided to start with an informative radio program for the people of this country. We are presenting a weekly program in which current topics, community developments and issues, and general matters concerning the people of Sint Maarten are discussed. Today we have a special guest with us in the name of Mrs. Brenda Brooks. Mrs. Brenda Brooks is a very known person, a great personality in our community. When I hear the name Brenda Brooks, for me, I always think that is a people's person. She is very known, she's very loved in our community because she has a passion for her country. Next to that, she has just an unconditional love for humankind, and she is always ready to help everyone that approaches her. As you know also, Brenda Brooks, as I said, is very committed and is very involved in developments in her country. And that is also the reason, as a political leader of the URSM, as of the beginning, one of the persons that I contacted when I was contemplating to start this URSM is that I came in contact, of course, with Mrs. Brenda Brooks, very reliable person, a professional. And as we can see how Sint Maarten is going now, I think we are in urge and in need of serious people, dedicated people, but also professional people with know-how to guide and help this country in a good direction, to bring this country back at a level that we will get prosperity again for the next generation. Mrs. Brenda Brooks, as I said, is a lawyer. She's a general lawyer. She handles criminal cases and also in general civil cases. She is very known for her immigration cases that recently we had a few of them last week that I will touch base with her on in this program. So, Mrs. Brenda Brooks, welcome. It's a great honor for me to have you here as the political leader of the URSM, the Unified Resilient Movement. And I think it's worth also to mention in the introduction that you became so enthusiastic when I approached you with my ideas to start a new political movement, that I got you even so far now that you are the board president of the Unified Resilient Sint Maarten Movement. We are very glad with you as a board president of this board. And of course, for this we want to thank you once more. Mrs. Brenda, welcome. Welcome to our radio program.
Thank you, Dr. Mercelina, and thank you for having me on this program. Indeed, I am an attorney on St. Martin, and I've been fighting. And to add a little bit more to my very busy life, I have decided to take up the challenge to be the president of the board of the URSM, because I firmly believe that it is time for us to not only talk but also walk the walk and get down to the basic things that we need to go and change for this country. There's so many possibilities for the country on a whole. And I think that if I sat here for 13 years and see what has been our development, especially being birthed a new country in 10-10-10, I think that this was my moment to say, okay, I want to be part of the solution and not part of the problem. Hence, I have decided also to commit to the movement.
We are very grateful for that, Brenda. And Brenda, you know, we have had a lot of conversations with each other concerning our concern for our country. And as you said, it's time now for us to put the hands on deck and just do what we have to do for our country. As we have many times in our meetings with the URSM, we always tell each other it's no time anymore to criticize, it's no time to be personal with each other. If we even discuss a matter that needs improvement in the society, that's not a problem. You should do that. But on the other side, we do believe that to be constructive and positive, once we discuss insufficient developments in our community, that we always make sure that we have a solution to present to the people of this country. And I really believe that the URSM is a movement that wants really to bring changes and contribute positively to this community, not only by criticizing, as traditionally all political parties has been doing, by criticizing, attacking each other, throwing with mud. We decided we are going to do it different. We're going to be constructive. And that is, for example, the reason that we started this informative radio program to inform the people, to educate the people, for us to have more a civilized community, that people know where they're standing and are well aware of all the developments in their community. Brenda, I want to start first of all with you, because these, as I said in the introduction, this radio program is also to discuss current topics, and if we can have it about a current topics nowadays of this past 2 weeks. It has been cases that you have been handling in court concerning some immigration challenges of immigrants that were illegal or illegal, didn't have the right documents, and you were the lawyer representing them. Recently, you have been doing this as in many immigration cases. Can you explain me a little, and not only me, Brenda, just explain the people of this country. Give us a introduction, a guideline about what the law entails if we are talking about the immigration policy of this country.
Okay, Doc. In general, I'll tell you this. Immigration law differentiates itself a bit from civil law, because where in civil law you have civilians going up against each other. My neighbor, for instance, build a wall on my property, is encroaching, then I have a civil case. In immigration law, it's what we call administrative law. To be even broader, it's public law. So when you say public law, it is the citizen versus the government. So in this type of setting, you don't have civilians against each other, but citizen versus government. And with all administrative cases, be it that you're going up against the Minister of Justice, the Minister of Romy, the Minister of Finance, whichever administrative body that you're going against, you do not say, for instance, in a criminal case, you're guilty or you're innocent, or you're right and you're wrong. It's more about you're looking at the general principles of good governance. So those principles, there's nothing written in the law, but it's in the jurisprudence. The jurisprudence give you an outline of principles of good governance that the administrative body, in this particular case, immigration law, it would be the Minister of Justice, have to follow. So they look at I'll give you an example. They said, okay, was the duty of care imposed? Did I study the file properly to come to the decision that I came to? The equality principle. You gave a permit to this person with these circumstances. Did I also do the same under similar circumstances with the other, or did I deny it? So you also look at proportionality principles. The decision that the minister take, is that in proportion to the interest that the minister has to serve? So you don't really look at guilty, innocent, and those terms, but you look at what the general principles of good governance. And one of those main principles is, of course, every decision have to be properly motivated. So there are several of them established in jurisprudence, but in immigration law, you're not really looking at the things that you look at in civil law. The aspects are a bit different. And one of the things that a lot of people don't know, and I would like them to understand, normally when you put in, for instance, an application at immigration, you, based on the jurisprudence, the law says the minister has to give a decision within a reasonable term. The law doesn't specifically mention what's the reasonable term, but the jurisprudence says in immigration cases, reasonable term is 4 months. So it means that if I put in an application and within 4 months there's no decision, then you can force, because our law acknowledges something that you call a fictitious refusal. So you would have actually after 4 months, 6 weeks after that term to say, I can go to court and I can force the court to force the minister. I could request the court to force the minister to make a decision. And a lot of people don't know that. And why I stress on it now is because people, we've seen situations where people sit over a year and wait for a decision.
Okay, Mrs. Brenda, let's, because we are here also to educate our people. You use very heavy words like jurisprudence. Can you explain to people what is actually jurisprudence? Can you explain the people of Sint Maarten that, so in the future when we use this word, people know, that is what the lawyer means with jurisprudence?
Yes, jurisprudence is basically case law. It is previous cases that were handled and the court ruled in a particular manner. So when we say jurisprudence, it's literally case law. Previous cases we use as example to show that this is what the court deems acceptable or not, and then we build on it.
I'm a person here on the island. I come to Sint Maarten, and actually they classify me as a undocumented person. What does that mean if I am a undocumented? What I do not have with me that people make the conclusion that I'm undocumented? That's my first question. After I'm undocumented, explaining us this, you're going to tell me, okay, for you to start now the procedure, because I would like to become a documented citizen in Sint Maarten. Can you explain to people of Sint Maarten what means undocumented and what must take place for me to get out of the circuit of being undocumented to start the procedure to become a documented citizen of Sint Maarten?
Okay, undocumented simply means that you're here and you don't have the necessary permit, which would be the resident permit to reside on Sint Maarten. That is the term that is used for undocumented, because you do have people who come in as tourists, and once you're within your tourist stay, we would not be considering you undocumented. We would say, okay, this person is within their tourist stay, and the tourist stay is actually depending on your nationality, which country you come from, whether or not your visa required. Our visa handbook describes how many days you can stay here based on your nationality. Now, there are procedures and they vary. Let's take this very simple procedure. If you have, for instance, Dutch people come from within the kingdom, they are allowed to be here X amount of time before you can say, okay, they are considered undocumented. Albeit that we do not consider people who move from the Netherlands to Sint Maarten required, for instance, to be off island while they're trying to document themselves. The case law, the jurisprudence did allow people to be here up until recently, and recently is April 2021, when the minister's guidelines were slightly amended. The minister stated that all first-time applicants have to be off-island. So it would be very difficult for me to sit here today and say, okay, you can come into Sint Maarten and you can start you can sit here and do your paperwork, because based on those guidelines, it is expected that all first-time applicants remain off-island and then they start their paperwork. Their paperwork would mean an application with a whole listing, because depending on the purpose of your stay, with any common law country, you always have to explain what is your purpose of your stay. Are you coming to reside with your spouse? Are you coming to work, for instance, for government? Are you coming to work for a company? There are different purposes for which you're asking for residency, and there must be a purpose. Now, having explained that, what is undocumented, and explaining briefly that there is a procedure which starts with an application and a whole listing of documents, and that you're required now in principle for all first-time applicants to be off-island, the next thing that is important to establish where immigration is concerned is that we do in Sint Maarten have a lot of undocumented persons residing on the island.
Yes.
And that stems, I'm here 13 years doing immigration cases. And that stems from way back when, because when we look at some of the cases that we recently did, we had persons living here 20, 30 years. And they were undocumented, some being never documented, and some being documented for a brief period. And that is a big problem, because now the next question might be, how do you get them documented?
Yes.
And in the past, of course, the government of the Netherlands Antilles, the former Netherlands Antilles, did do several grace periods, one being the Brooks Tower was the last one that I personally experienced. And I think one of the issues with the Brooks Towers that happened back then is that you gave someone a permit once they could have proven that they were here for all those years before 2009, if my memory serves me well. You would get 3 years permit, but under the condition that they immediately, after the 3 years, would have to fall under the regular laws to document themselves. And a lot of persons who did initially get the 3 years permit, unfortunately, because of the stringent rules, they did not qualify for the regular permit, and hence you get an influx again of undocumented persons, albeit that they don't want to, but they just simply don't qualify.
But Mrs. Brooks, we have here in this country a major challenge with the immigrants than actually the group undocumented. Honestly, I have nothing against them, because they contribute in their way also to the local economy of the country. And people that are here legally also use them and also misuse them. So this knife cuts on two sides.
Right.
But we still have our challenge of our undocumented, actually illegals on the island. Just now you told me that the possibility to apply for a resident permit is that you have to be off island. But those that I'm talking about, this huge group, is actually on island. And on the other side, you have a government that say, okay, I have a big group of illegals here on the island, but they have to be off island for us to start the procedure. What do you think should be an in-between better solution for us to start structurally solving those that are here on the island already? Because that is our challenge. We're not getting hold on those here already. Imagine those that are planning to come in, that will continue coming in the island without us getting a good hold of them. What do you think we should use as an in-between formula to at least get a little a overview and hold on the undocumented that are here on the island already?
Well, to start with, I do believe that we need to at least go towards another grace period. It might sound a bit pro-immigrants, but right now there are a lot of persons that have been residing on St. Maarten for quite a number of years, and in fact we've had cases in which once you can prove that the immigrant has spent the majority of his or her life on St. Maarten, then it's a hardship for them to return back home. So because actually you don't know home, this is home for you
years.
now. So what I think first we need to do, we need to find a way to regulate those that has been here for all those years and not require them to leave, because requiring them to leave would put a hardship on them where they have to find a substitute living situation abroad, be it temporary or not. And by the way, it will be a problem because based on the 2021 guidelines from the minister, it specifically states that persons who lived here illegally before, if they want to apply, they have to leave the island, but not only leave, but they have to also stay out for 3 years. And you have situations, Doc, where some of those immigrants birth kids here and the children does not know their mother's or father's home country. So it's difficult to disrupt the livelihood of those kids as well who do not know anything other than St. Maarten.
Actually demanding a person that is for years here, got children here on the island, to tell them, okay, now you guys all have to move, and once you're off island, you're going to start the procedure to apply again. I think it's a little unrealistic too for us to get a good hold on the immigration issues that we have in this country.
Correct. And I think even one of the things that you can always fall back on is the term that we say based on humanitarian grounds. Now, I would say you start with a grace period and try and see if you can get people to come forward out of the illegal circuit and document themselves. And at the same time, you're going to find a group of persons that immediately qualifies for permit based on humanitarian grounds. You can't send them back to Ukraine and Haiti and those war zones right now. And then you say, okay, let's move forward. And I think if you get that where you say humanitarian grounds, allow them to stay on the island, give them dispensation, because the minister can do that. You can waive the off-island requirement in those particular scenarios. So just do that, and then let's clean it up a little bit and hope this time you don't tell them, okay, we're going to give it to you for 3 years, and then after we put stringent conditions. It doesn't make sense to do that, Doc. It has failed in the past, and it's going to fail in the future. Why? Because if I'm good enough to get a permit for 3 years and I can survive and live, what was the problem to give me continued stay, to allow me to continue living? Why put me under a stringent category to go try to get back the papers, again to fall back in the undocumented circuit? Because then what happens? You're actually defeating the purpose of the grace period.
The grace period, of course. Ms. Brenda, we are going through a very interesting topic of the challenges that we have as a country concerning immigration. Time is flying on us, and unfortunately we will have to take a break, and we will be back in a few minutes. Dear people of Sint Maarten, welcome back to the second half of our radio program, URSM President. As I've mentioned in the introduction in the beginning of the program, today we have with us Mrs. Brenda Brooks, a very known lawyer here on the island. And of course, for me, very important to mention is Mrs. Brenda Brooks is the president of the board of the URSM, the new political movement, Unified Resilient Sint Maarten Movement. That is a political movement that is aware about the challenges, the cry of the people of this country. And we from the URSM really believe that it's time now for us to pull up our socks and do what is necessary for an improvement of this country. Brenda, welcome back in our second half of our program. Brenda, recently, last week actually, you have been in publicity with some developments that took place in court concerning some immigrants. Can you explain actually what all these cases were about? And it would be nice that you, for example, enlighten on the base of those cases what went wrong in adhering to the policies of the justice of this country.
Thanks, Doc. what we did, the cases were actually handled on Friday before last, and we got judgments on Tuesday last week. And what transpired is the following. We know that there were several immigration raids. I think St. Peter's was one area that was raided. Boardwalk was one area that was raided. We understood also on the Simpson Bay Strip there were raids carried out. When we got some of the cases, of course, as attorney, you have to go and check to see were proper procedures followed. Because, again, if you're looking at what the Minister of Justice has to do, ensure that the principles of good governance are adhered to. We've reviewed the documentation that we finally received, and we understood from our clients that they were placed in immigration detention. No form of communication, no paperwork was given to them.
Who imposes this immigration detention?
Based on the law, the authority is from the Minister of Justice, who actually signs a immigration detention order, along with the Chief of Police, Mr. Carl John, or anyone that has the mandate to act
from the minister,
on behalf of the minister or Mr. Carl John. So normally, what happened when you look at the procedures, you're supposed to pick somebody up if they cannot identify themselves or they do not have the proper paperwork. If you verify that they are illegal, you're supposed to, within the first 6 hours, you need to hear these people. Okay, you have to bring them forward a help officer, which is a so-called acting prosecutor. It's just a high-ranking police officer that is referred to as the help officer. The help officer comes into play because they have to see if also the measure that is being, the detention that is you're holding the immigrant, if that is necessary, because technically the help officer can say, listen, this was nice and dandy, but we're not keeping this guy or this lady.
Yeah, but it's something very important you're doing with people too. You're actually depriving them from their freedom.
Yeah, correct. And that's why it is always important to note that when it comes to detention, you should not take it lightly. It should be, especially in immigration cases, it should be the ultimum remedium to say, okay, I can't do anything else. I am going to go over to detaining the immigrant. But there's a certain evaluation that needs to take place. And in all the cases that we did, it was established that that evaluation never took place. The measure was first imposed. You are supposed to first hold them, sit down and question them, have the help officer do the part of the arraignment and whatever. You have to hear the immigrant out to see if the measure is necessary, because there's something called the meldplicht, which is my obligation to report on a weekly basis at immigration to let them know, okay, I'm here, I didn't run away, I didn't skip the boat or whatever. But that was not done.
So they just picked them up. They are in detention.
Yep.
And afterward, they didn't follow the procedure. So
Nope.
they just isolate those people. They deprive them from their privacy. And then we assume that it's okay what we're doing with the humankind.
Yeah,
It's
and apparently it has been going on. It didn't just happen. It has been probably common practice. Is now that I got cases that I said, okay, let me look at the paperwork and let me understand what is going on. And then when you start to ask for paperwork and it's not forthcoming, then you know, hey, we have a little problem, because if the paperwork is available, then it should be immediately given. And you should say, okay, this is the measure. But I heard the immigrant before. But in all the cases that I did, the immigrant was heard after the measure was imposed. And that on its own created a problem where the court agreed with us. There's an unlawful detention, because you're picking up people, you're not hearing them, you're not doing the evaluation to see if the measure is needed, because if you can go to a less severe measure, of course, the court will always agree a less severe measure could have been imposed. So having done that, now we have now, at least from my office, there were 3 cases of unlawful detention. 4 actually. One did not play out in court because the gentleman was released, but it doesn't take away the fact that 4 clients were unlawfully detained, some up to 35 days. The other attorney had her client as well, unlawfully detained, and we are not mentioning the ones that were quickly deported from the
So
period
that means in this country that we can, the way it's going now in practice, as has been became clear in the court case, that authorities nowadays can just pick up somebody, put him in detention, and keep him for 30-35 days without following the right procedures.
Yeah,
and that's incredible.
And the funny part about it is the procedures are not just procedures, it's procedures also imposed by the Minister of Justice. So that's why the court also did consider that their own procedures, the minister did not follow her own procedure, and by extension her staff or whoever did the actions.
But Mrs. Brooks, take one of the cases. It's not about mentioning name. We have to make sure that we guardian the privacy of your clients. But give us an idea about a court case like this. It went wrong, for example, that she or he was in detention for 30-35 days. There was no help officer to check, to have the necessary check and balances if we were correctly busy, isolating, depriving somebody from his privacy. What went all wrong in a case that you had, for example, last week?
Well, we had, there was no, actually they stopped them and they started a search. So they admitted in their paperwork that they searched the immigrant. Now, a search could only happen if you're considered to be a suspect. So in our opinion, the search already started wrong because there was no reason to search the immigrant, pat him down and search. Then the measure is imposed without hearing the immigrant, because the hearing of the immigrant takes place days after the minister signs the order. And by the way, the detention order comes days after the actual detention. So you impose a detention, the actual imposement of the detention happens. 2 days later, the minister signs the measure, and then 2 days later, the immigrant is heard. And while the minister is signing her detention order, for instance, in one of the cases, it happened on the 7th. The immigrant was only heard on the 9th, but yet the documentation made reference that the minister took note of the statement of the immigrant, which is technically not correct because that statement comes 2 days later. And that is exactly how I can best explain that the procedures were not followed correctly, because at the end of the day, you cannot start at the back end of the procedures. You have to start at the front end. And the experience has shown that when you start making errors on the front end, the errors trickle down all the way to the back, because it's like a chain reaction. If you need to make sure that there's a hypophyseed and that hypophyseed is not there, and then you have to make sure that the immigrant is heard and the immigrant is not heard, it continues trickling down because you start to make errors, and for some reason, once you skip the important parts of the procedure, you will continue making errors, and errors once made cannot be corrected. So you can reverse and say, okay, let's start back, because then it already classifies the detention as an unlawful detention.
Yes. And once more, Mrs. Brooks, we are discussing this not because we have to be personal or we have to be against the Minister of Justice. No, it's just that we want, in a democratic state as Sint Maarten is, for us to make sure that we do the things the correct way, that we have our check and balances at place, that we do not go over the human rights of individuals, depriving them, for example, of their freedom. So we have to just make sure that the things that we actually, the policies that we documented, that we just adhere to our own rules of the game.
Correct.
Okay. So in the beginning you told me the immigration detention, the immigration detention is an order from the minister. So once they are in detention, there is a second follow-up on this, and that is the deportation order.
Yeah.
Can you explain us a little about that part and who imposes that?
Well, the deportation order as well is imposed by the minister. The minister has the sole authority to decide over our borders. So it would mean that the deportation order comes from the minister. And usually, if I understood it correctly from what the attorney argued 2 weeks ago Friday in court, usually what happens in Sint Maarten is that once you pick up the immigrant, The two documents are immediately prepared. I was actually shocked that that was said because, again, a deportation order should not automatically happen. You have to prove that it is in the interest of the public order and safety. So at the moment when you have not spoken to the immigrant to find out the immigrant's story, their circumstances, you should not be imposing a deportation order immediately. I would think that the deportation order comes after that, the checks and balances, as we would call them. But seemingly in Sint Maarten, it has been the procedure that they issue both, they draft both documents and have the minister simultaneously sign both documents at one time without doing the proper checks and balances, which again, then you have principles of good governance that are not adhered to, because how do I motivate my reason for having this particular immigrant deported and why not the other one that has a meldplicht, for instance? Mm-hmm. So it's a bit funny to see that that's how it has been done. Maybe I can't say that it's something new or that they have been doing it for years incorrectly, but I can't imagine that it is known how it should have been done, because the arguments presented during the court case didn't give reason for me to believe that the ministry knew that these were their own procedures that had to be followed.
Just, Mr. Brooks, first of all, if I'm a person in detention because of illegality of my documents, I do not have legal documents. But the first thing is that I can look for a lawyer to help me. Mm-hmm. The first mission I have with that lawyer is to suspend the detention of immigration. That's mm-hmm. the first one. Mm-hmm. And secondly, that is just to make sure that the detention is a correct detention, is based on facts, and it's correct after the Hulpofficier did his part. And secondly, there is also a request for an extension of the deportation order, right?
It's not an extension, but it's really we're asking also to suspend. Yeah, in this particular case, these cases, we are also challenging the deportation order that we find was not properly motivated. Among other things, that procedures were not followed. So you have to ask the court as well, because once released, it doesn't necessarily mean that the deportation order cannot be carried out by the minister. And how you can do that is by releasing and taking them straight to the airport the same day and deporting them. So you have to make sure that at all costs that you request the suspension as well of the deportation order. So those procedures are starting this week. We have one of the first one is going to be on Wednesday. We're going to ask the court as well under the similar arguments why we are of the opinion that the deportation order cannot stand the legal test. The mm-hmm. test where we're going to say the procedures were properly followed, the principles of good governance were adhered to. We firmly believe that they were not adhered to. Same as the detention order, the deportation order would have fell for the same reasons that we outline in those procedures.
Okay. Mrs. Brenda, these are of course cases that let's call them illegals, are already on the island. We have to deal with that too, because it's a fact that these people are residing on the island. On the other side, looking forward in the term of prevention and better organization, actually for us not to get ourselves in these types of law cases, it would be great if we had a better grip and overview about our immigration. I do believe it's a quite difficult topic to try to organize, because we have here on a small island already two governments. We have the French government and we have the Dutch government. We have actually also, we are using our Princess Juliana International Port. We are using it also, and the French are using it for the Air France to land here, for those people to go through our airport, go to the French side. How do you think that we should solve in organizationally wise our border control to get a better hold on our immigration, only taking into consideration the fact that we have a small island already divided into different nationalities and governments.
You know, one of the things I remember back in the 80s, I was a young child, maybe in late 80s, 90s. I remember Aruba had introduced a whole stringent immigration system, and I always say, but why Sint Maarten didn't do the same? And when fast forward to 2022, after 13 years of doing immigration cases, you realize that the two countries on this island need to cooperate with each other on several levels, but on immigration matters, it's a must. And when I say it's a must, it means that if you have visa requirement for the Dutch side, similar visa requirements should be for the French side. And I've seen a case years ago. I was on the French side. That time I was residing on the French side. And my neighbor, he was telling me if he comes in Juliana Airport, but he gives them a Dutch side address, he needs a visa. But if he comes to he tell them he's coming to the French side. And I thought about it and I said, but this is crazy. You have one island, two different governments. And it should not be that one side have a list of countries that are deemed visa required, and then the other side doesn't have it, and then you can just come in and say I'm staying at a French side address, and then there you go get the same problem that the person overstays and then falls into the entire illegal circuit and it starts again. Also, one of the things I think should be done, which I don't think there's much people understand what compliance is, okay? Mm-hmm. We have a compliance department in Sint Maarten on the Dutch side, something that was recently established after COVID struck the island. Compliance should not be that I'm in the front end. I firmly believe that compliance should be in the back end. Why I'm saying the back end? The department is most efficient at the back of the procedure to make sure that the person who is issued a permit or who is issued entry into Sint Maarten for tourist stay or whatever, they are the ones who should be following up to say, okay, someone came by Dr. Messalina, they gave up Dr. Messalina's address, they're going to be here for 30 days. This person did not leave the island. Hey, we need to check by Dr. Messalina's address to make sure, because then he's aiding and abetting an illegal immigrant. You understand? Mm-hmm. But there's no follow-up at the back end. And this is where I find that the compliance department, normally compliance toezicht should not be on the front end. I cannot do toezicht on the front end. I have to do it on the back end. So if you take away all of the unnecessary job description from these people from compliance and say, guys, compliance should be on the back end, verify, then you get a more efficient working immigration apparatus that are going to go and verify that the people them actually leave when they are supposed to leave, and not that they are overstaying and they did not leave the island or they did not extend their tourist stay. And that's what I understood Aruba does very well. Once you come in and you say 30 days, guarantee if you're not out, they're coming to look for you. Mm-hmm. But nobody does anything in Sint Maarten because I guess we find our excuses and say, okay, manpower, we don't have this. But you have manpower. You implemented compliance. Compliance should not be minding what happens for you to get your permit. Compliance should be checking. Now you got your permit. Now you have your visa to enter Sint Maarten. Now you have you come in as a tourist. Let's go now to make sure that you leave when you're supposed to leave. And once you get that apparatus moving how it should be moving, you won't have people, you will deter people from overstaying. Of course, you still need a French side because yes, we can skip and go over to the French side. But if Juliana is one of our main ports of entry for most of the immigrants, then make sure that we can have a sort of an overview to make sure that they leave when they are supposed to leave as well. But you need to do it jointly.
But Mrs. Brooks, the execution of our laws, that has been a handicap for years for our country that has us today in the position that we are. The other topic that is for us also quite challenging is, for example, the last development of a lot of Venezolanos and Venezuelans here on the island. I recall that in Curacao, for example, there was a big influx of Venezolanos. At a certain moment, it was becoming a threat for a balanced financial, economic situation for island Sint Maarten. And I can recall that the government had a discussion with the kingdom government about this. And it was not clear, in the case of the Venezolanos, the Curaçaoeans thought that the Venezolanos were here because they were political refugees, politieke vluchtelingen as they call it in Dutch. And the Dutch in the kingdom were stating that it was not a politieke vluchteling then, because then they have to assume the responsibility because they have foreign affairs under their control. But then they said, no, they are economic refugees, they are economische vluchtelingen. Do you see a solution, for example, for us to get a better hold of the influx of Venezolanos here on the island? With all respect, due respect, because they're great people too. They contribute to the local economy that are in construction on our island. It's not about that. It's just that if we want to be serious with the future of Sint Maarten, those sensitive topics must also be tackled.
Yeah, well, again, it all goes down to your immigration control, huh?
Yep.
Because indeed we have most of them somehow on the French side allow them to do asylum, but on the Dutch side you're not going to get asylum because of the whole discussion that was held between The Hague and Curacao in the past.
Yep.
It's really not political asylum they are seeking, but they are looking economically for a better future, and we should come to some kind of understanding. Okay, what are we going to do? Are we going to accept them, yes or no? Once we figure out if we're going to accept them, yes, or we're not going to accept them, then we need to close the borders from them. We cannot say, okay, we're going to let you come in and then they disappear on the French side or vice versa. And this, again, you need a joint immigration control system between both islands, because they find their way in through the French side and then they get some type of asylum over there, and then they come to the Dutch side, and then there again we have a problem, because French side is not talking to Dutch side and Dutch side is not communicating with French side.
Yes.
But yet every Sint Maarten Day we stand and we say, hey, unity.
Yes, one island.
We want cooperation, one island, one people. But one island, one people means that you also have to make sure that the one island, one people come up for each other. You have to make sometimes it's hard decisions. If we say no, we're not going to take them. One thing we have established with the Venezuelans, they're not here robbing you.
No.
You know, they're hard-working people, be it here, be it Mexico, be it U.S., wherever they go. Trinidad had a whole exodus of them too. You have to come to some kind of agreement. What are we going to do with them? Are we going to help them, or we are not going to help them? Are we going to help us X amount of them? Something you have to come to some consensus, and nobody wants to touch the topic until it's time to go and raid the place, and then you pick up all of them, you send them back, but they're going to find a better place somehow, somewhere.
But, you know, Mrs. Brooks, it's about lack of vision of government too. As you said, at a certain moment, you have to take a decision to have a vision and a regime. How do you want to tackle those issues? What is your vision on those Venezolanos coming to Sint Maarten? Once more, nothing against those Venezolanos, but it's a small island. It has a vulnerable economy. So we will have to know, okay, are we okay with all those Venezolanos coming? Yes, okay. If you're not happy with it, okay, what is our stance on it? What is our regime? What is our policy? Where do we want to go with this growing problem in our community, of course? It's not, as you said, that they are in criminality. No, they are hardworking people that are coming to improve their economic situation, of course, and that right everybody has. But as a country, we have to guardian, of course, for us to keep a balanced community. And a balanced community can only be maintained if you have a good immigration organization too. Mrs. Brenda, it was a great topic that we were discussing today with each other concerning immigration. Unfortunately, time is running on us. Ladies and gentlemen, we will have to end this great program for today because time is, as I said, running on us. Mrs. Brenda Brooks, I would like to thank you enormously for being guest in our radio program.
Thank you for having me, Doc.
Okay.
It is my pleasure. Wherever I can try to share my knowledge, I do my utmost, because at the end of the day, that's one of my key goals in life, is to share knowledge. Knowledge is power, and this is the only way we can get it out to everybody, to educate them a bit, because not everybody can afford to go law school and to know the laws and learn the laws. So however I can help, and that is also the basis for my foundation at Brooks & Associates. I try to educate people, and I try to make the clients non-reliant on me. I'm not the type of attorney that every step of the way you need to call me. I try to explain you in a way that you can save yourself and guide yourself, because the goal, the eventual goal, is that you should have learned something when you pass through my office. So don't expect me to be holding my client's hands all the way. I give you the tools and I teach. And that's what consultations are also meant to do. You teach people things that they are not, the information that they are not privy to. And that was also one of my motivations why I joined URSM, because I said, I can sit back and let it just happen, or I can try to be a solution, come with solutions. And I'm not here to criticize anybody, but it's time that we start to think and put things in place to move forward. And that is what I find is quite lacking in St. Maarten. There's a lot of laws need amending, but we're not amending them. But yet we go and say, hey, we need to adjust the laws in St. Maarten, but the ones who are there to adjust them are not adjusting.
Yep.
And a lot of the laws are outdated, and we need to also work towards that. We cannot keep sticking in the days before 1010.
Absolutely.
We have surpassed that.
We have to move forward with this country.
And growth. Just like a child, you need to grow. You start to creep. You crawl, you walk, you run.
And also, you have to be an adult too.
Yeah, and
okay.
That is my motivation.
Thank you. Mrs. Brenda Brooks, once more, thank you very much. It has been a great honor to have you here in our radio program. Ladies and gentlemen, thank you for your attention for our radio program, St. Maarten, and looking forward to have you back in our program next week, Wednesday, from 6 to 7 p.m. on Radio Mix 94.7. Have a great evening.